USCIS is cracking down on marriage-based green card cases. Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, San Diego, and Washington, D.C. USCIS gave an announcement recently that on August 1st, the agency updated its policy manual and detailed how they're going to start handling marriage-based green cards moving forward. We want to talk about all those changes in today's video and bring you up to speed, because if you are an immigrant going through this process, you need to know these changes because they're going to affect exactly how your case will be handled. So the agency made 3 significant changes to the policy manual. The first is, for the very first time, they gave us a list of those instances in which they believe that an interview will be required. They're telling officers, if you come across one of these 10 or 12 scenarios, you are required to inquire into the validity of the marriage. The second big change to the policy manual was that they are making it clear that just because you file an I-130 petition for someone, that does not slow down or negate the ability of USCIS to issue that person a notice to appear. So this is going to have a big impact on people who are out of status in the United States, who marry a U.S. citizen and are seeking an immigration benefit. So we'll talk about that. And the third major way that USCIS changed the policy manual was they are not going to just blanketly accept that every document you provide to the agency is legitimate. They are going to make sure that every document is verified. They're going to scrutinize every birth certificate, death certificate, marriage certificate. They're not going to assume that you are acting in good faith. They're going to require officers to demonstrate to the satisfaction of supervisors that these documents that you've submitted in support of your case are legitimate. Let's talk about change number 1, when an interview is required. Now, over the years, through the Freedom of Information Act, our office has been able to obtain the fraud indicators list from USCIS, the things that officers do to determine whether or not they want to conduct an interview or a site visit. Well, now USCIS has added a new section to the policy manual to clearly set forth when an officer is required to conduct an interview. The first scenario in which USCIS will require an interview is if there's missing evidence or inconsistent answers in your I-130 or your I-45 application or the supporting documents. If USCIS officers believe that the marriage is not real, or they have confusion or questions about what you have in your case and why things don't match up, they are now required to conduct an interview and to talk to you and your spouse about whether this marriage is real and whether the beneficiary is deserving of lawful permanent resident status in the United States. Similarly, if the officer finds that there is inconsistent information in the forms or derogatory information in the backgrounds of either the beneficiary or the petitioner, that is, criminal records for either the person sponsoring or the immigrant being sponsored, USCIS is required to conduct an interview and ask everything about those instances. Tell us about those arrests. Tell us about these inconsistencies. Why should we believe you? Why should we give you an immigration benefit? Why should we use our discretion to give you the foreign national immigration status and a green card here in the United States? Marriages in which the couple were very young, 16, 17, or the U.S. citizen was very young and the beneficiary was more than 10 years older, those cases are going to be scrutinized very heavily and they will be required to have an interview. You may know that if USCIS doesn't think that a party has carried their burden and demonstrated that the marriage is real, that they can issue what are called requests for evidence or notices of intent to deny. These are tools in the toolbox of the immigration officer that they can use either before or after an interview. And so now the guidance is clear. If an officer issues a request for evidence or issues a notice of intent to deny, they could flat out deny the case if they don't like the response, or they could call the people in for another interview. Now that's a broadening of their powers. The officers are now being given a little bit more power to just flat out deny cases in which they feel that your response to a request for evidence or a notice of intent to deny is unsatisfactory, that you did not answer the questions or provide the information that they requested. Your case could be flat out denied, or you could be called in for another interview. You can also count on getting an interview if the petitioner, that is the U.S. citizen or lawful permanent resident who is sponsoring their foreign-born spouse, has sponsored someone in the past, or if they themselves were sponsored. So when people get an immigration benefit and then turn around and sponsor someone else, or if USCIS thinks, hey, this person has married 1 or 2 or 3 people and given immigration benefits to all of them, you can be sure that the petitioner and the beneficiary are going to be called into the immigration office, and they might have to get USCIS to believe that not only is this current marriage valid, but also the prior marriages were valid, that they were for love and not just to get an immigration benefit. They want to make sure that this petitioner is not just someone who marries people to get them marriage-based green cards. At the same time, you're also going to see if a beneficiary has been involved in prior marriages or prior immigration benefits, and even if those cases weren't necessarily denied, but they were withdrawn or they remained pending and USCIS was never notified, you can expect that if the beneficiary has been involved in prior marriages or prior attempts to obtain lawful permanent resident status through marriage, that they too are going to be interviewed by the officer. Interestingly, USCIS also listed two situations that have always required an interview at USCIS, and that is where the petitioner obtained lawful permanent resident status through marriage and now is sponsoring somebody else. So this is what we call in our office a pivot case, where somebody gets a green card and then divorces the person that sponsored them and quickly marries someone else, usually from the home country, and sponsors them for a green card. Those cases have always been subject to extra scrutiny, and interviews will be required for them. Also, a long-standing rule at USCIS is that if you are in removal proceedings at the time that you get married or the time that you file for an immigration benefit, you can count on getting an interview. So when someone is in removal, USCIS sort of assumes that the marriage is just to get an immigration benefit, to get them out of removal. You have to prove your case by clear and convincing evidence, and in order to meet that burden, USCIS is now required to have an interview for those people. And then finally, the last one on the list is the old Stokes interview. So a Stokes interview is when USCIS doesn't believe the marriage and they call the couple in and they separate them. So officers are specifically authorized now that if you've already conducted an interview, or if you're in the middle of an interview and you don't think that this marriage is real, you can go ahead and conduct a Stokes interview or schedule them again for a Stokes interview or a site visit at their house to see if the marriage is real. So that is the last category of cases in which interviews are going to be required. So what can we make of all this? What do we think about the fact that USCIS is now setting forth those instances in which an interview is going to be required? I think part of it is that they want to get it all into the policy manual. Part of it is that they want to scare people and say, hey, if you have one of these cases, you can expect to be held to a higher standard and you're going to get extra scrutiny, because they want people to not file. They want them to be scared. They want them to be worried about whether or not their cases are going to be approved or not. And so in my mind, this is really a time where you need to think about having an attorney help you through the whole process. The next big change at USCIS as a result of this August 1st memo, USCIS is not going to speed up your I-130, and they want you to know, and they've clearly set forth in the policy manual, that just because you file an I-130 petition for your spouse, that does not mean that ICE or USCIS won't give your spouse a notice to appear in immigration court. In other words, you are out of status, USCIS knows that you're out of status, they could issue you a notice to appear in immigration court before your I-130 interview, at your I-130 interview, or after your I-130 interview. So if you look back at Project 2025 and you look at the assumptions that USCIS and ICE want to make, is that if they come across anyone anywhere in the country, it could be at Home Depot, it could be at a church, whatever it is, if they find someone who's out of status, they can put them into removal proceedings and commence deportation proceedings against them. Remember, they have a quota to deport X thousand of people every single day. And so they're under a lot of scrutiny to find as many immigrants as possible. Well, what better place to find immigrants than at USCIS, who are trying to get an immigration benefit? Historically, when a U.S. citizen has sponsored their spouse, if they're out of status, that spouse would not get a notice to appear before their interview or at their interview or after their interview. But I think you can expect now that if you're out of status and you've been in the United States for a long time and you're married to a U.S. citizen, and your U.S. citizen files an I-130 petition for you and you file for adjustment, you're still eligible for adjustment of status, but ICE, in order to hit its numbers, is going to make sure that you get a notice to appear in immigration court. That's going to make your case much longer, much more expensive, because you're going to have to fight the deportation, and most importantly, much more stressful, because you're going to have to go to USCIS. Maybe you've already received your notice to appear, maybe you're anticipating getting one, maybe you're even worried about getting taken into custody. So these are going to be very, very stressful cases now, because people are going to be headed into an interview and they are not going to know exactly what happens. So if you were in status at the time that you filed, I think you'll be okay for now. I don't think you'll receive a notice to appear under these changes to the policy memorandum. But if your status ends during the pendency of the case, in other words, let's say you're an international student and you stop going to school while you're writing your green card case, If that case gets denied, then you would get a notice to appear. Now, a lot of this is a little bit silly. And what do I mean by that? Well, even if you are out of status, and even if USCIS or ICE gives you a notice to appear in immigration court, if that I-130 gets approved, which hopefully it will because you have a valid marriage, you're still most likely going to be able to stay in the United States. You're going to be able to either adjust your status in immigration court with your approved I-130, or you're going to be able to ask the immigration court to kick it back to USCIS so that you can adjust your status there. So for a lot of people who are out of status, I still think you have to go ahead with the process. You still have to anticipate spending more money. You have to anticipate the possibility that you're going to be put into removal. But for those people who've been in the United States for less than 2 years, I think this is a really big problem, because under the Trump administration's interpretation of expedited removal, they don't have to wait for you to get your I-130 approved. If they know you're here out of status, they can just put you into expedited removal if you've been here less than 2 years. I also think people who enter on visa waiver program who don't have all those same protections as people who entered with an actual visa also need to be concerned about these changes. So the big thing you need to take away from all of this is that if you're out of status and you're applying for an immigration benefit, things have changed. Just getting your I-130 approved is not going to keep you here, and that's exactly what it says in the language of the update, and I want to read it to you. Section 3, removable aliens. If USCIS determines the alien beneficiary is removable and amenable to removal from the United States, USCIS, that is the agency that's adjudicating the I-130, may issue a notice to appear, placing the beneficiary in removal proceedings. Petitioners and alien beneficiaries should be aware that a family-based petition accords no immigration status, nor does it bar removal. So they think that they're going to be able to remove a fair number of immigrants who are going through the immigration process, even though they're married to a U.S. citizen, even though the law says that they are eligible for adjustment of status. Based on this policy change, they're saying that if we know you're here and if we know you're out of status, we're giving you a notice to appear, and then you can sort it out later with the immigration court years from now. A big change, a big headache. The third big change in the updates to the August 1st policy manual is that they are now going to scrutinize every single document that you submit. So USCIS has long felt that they've been the victims of all kinds of document fraud, and so they are empowering officers to inquire into the validity of every kind of document that's submitted to them. Now, this is right out of Project 2025. This is exactly what they said they were going to do. And I will tell you this, as someone who's been practicing immigration law since 2008, I can count the number of fraudulent document cases that we've come across on probably two hands. Now, USCIS spending all of this time and energy to track down documents to see if they're real is really designed, I believe, number one, to scare people, but more importantly, number two, to just slow down the whole process, because they know that if a particular officer is out looking into whether your divorce decree from Rwanda is legitimate, then they are going to be slowing down the adjudication of the cases themselves and keeping the officer from doing other important work. So I believe this last change is really designed perhaps to find immigration fraud, but much more so to find ways to slow down legal immigration to the United States. So I hope you understand the severity of these changes. I wrote a blog post that you can find on our website. We can put a link to it in the comments so that you can get it all down in writing. I think this is a big change. I think not enough people are talking about this. I made this video so that you could understand what's going on. I ask that you please share it with other people that you think might be impacted by this. I really think things are going to change at USCIS, especially with all this new funding that Homeland Security is getting to find and deport as many immigrants as possible. If you're filing for an immigration benefit and you want our help, you want us to be your lawyers from now until you get your benefit, and maybe that's an immigration court, give us a call at 314-961-8200. Email us info@hackingimmigrationlaw.com. If you're just looking for free resources, that's okay too. We have our Immigrant Home Facebook group. You can talk to other people going through the immigration process. We have our YouTube channel that you can subscribe to. Whenever we make a new video, you'll get updated if you turn on the alerts. And finally, we have our TikTok at Immigration Hacking, and our live show that we do 3, 4, 5 times a week. That's the Immigration Answer Show. You can subscribe to it on YouTube or Facebook. You can also text the word SHOW, SHOW, to 314-470-3300, and you will get a text when we're about to go live, like we are today in just a little bit. Thanks so much, and we'll see you next time.